that I'm being joined by a member of the APC, a lawyer, and a member of the Lincolns in London, Mr. Daniel Bwala. He joins us from our Abuja studio. Thank you so much, Mr. Bwala, for joining us. We have a minute before the break for us to continue the conversation. But before we go into that break, tell me, in several states like Osun, Ogun, there are parallel conduct of the exercise. In Kano, those members loyal to the governor are in disagreement with those members of the Buhari support organization on the manner in which the elections should be held. People are not happy in several states. This will have a far-reaching implication for your party. Is this a great danger looming?
No, there's no great danger. Actually, there is an age-long principles of law that says that what determines the conduct of either congresses or primary elections is that which is conducted by the national body and not the one that is conducted by the state. So in all the places where you find these factions, as you call it, the only one that will be recognized by law is that faction that is sanctioned by the national office of APC, because that is the law, that it is the National Working Committee, or in this case the Caretaker Committee, that conduct congresses and conduct primaries. So any other person or group of persons that parade themselves as a faction, howsoever they call their names, it is not even a big deal. It's not something to worry about, because there is an age-long principles of law.
We take a breather, Mr. Bwala, and we come back to it. Up next on the program, everyone. When we return, Mr. Jibrin Okutepa, he will be joining us to discuss the meeting of the CJN, the NJC, and with some leaders of the court in Nigeria over the conflicting court orders. And of course, Mr. Daniel Bwala, who is being with us, will be discussing with us the APC Congress aftermath, what the law says, and the future of Nigeria's ruling APC. Join us again, everyone. We're all set to serve you with the second segment of the program. Thank you so much, everyone, for staying with us. Some of the doses that we have for you. Mr. Daniel Bwala is in our Abuja studio, and he will be touching on the aftermath of the congresses of the APC, the local government congress, and some of what came in the yesterday's congress across the country. Of course, we have from Bahamas the senior advocate of Nigeria, Jibrin Okutepa, who joins us from Nassau. I will be coming to you in a moment, and we'll be talking about the conflicting court orders. Thank you so much, gentlemen. Let me go back to our Abuja studio and just for a moment discuss the situation in the APC. A lot of people seem not to be happy. For example, Ogun State. Last week, there was a launch of the World Congress leadership, and it was different factions. The factions loyal to the governor and the faction loyal to the former governor, Senator Amosun. And during the LG Congress on Saturday, there were two different factions also holding the Congress. But you said that in the eye of the law, the national body of the party is responsible for conducting it. But you and I know what this means for a political party. You guys always say that it's a family affair. But in the real sense of it, it goes deep down in dividing the party, leading some people to leave the party at some point. When you have a sitting senator, a former governor, and a sitting governor at loggerheads, the same thing happening in Osun State. There are parallel congresses in Osun State. The party, the faction loyal to the former governor and the faction loyal to the sitting governor holding parallel congresses. It's a division in your party, isn't it?
Well, this is not strange, actually. From 1999, in all, even when PDP started, actually it's with all political parties. That is what we call the jostling, the pull and push in political process of the control of party structure. You have rightly put it, former governor and incumbent governor, or former this and incumbent this. So it is natural for somebody who has held the structures under his hand and control, but is no longer in charge, to want to have control. And the one who is in charge, who is the leader of the party, would also want to have control of the structure, because the idea is that if you have control of the structure, you are likely to determine what is the outcome of election consequently. But whether you are interested or you are not interested, you are former or present, the APC is guided by its constitution and the guidelines. We have guidelines for the conduct of all the congresses. And if you look at the guideline, what the guideline provides is that the extraordinary caretaker committee will form a committee for the purposes of conducting all of these congresses. And the committee are going to be formed from the national office, consequent on not just the constitution, but plethora of decisions of even the Supreme Court, that it is the national body that conduct election across the country, but not the local party branch. So assuming the national committee, the National Extraordinary Caretaker Committee now create a committee for the purposes of conducting an election in any of these places you have mentioned. That committee is the one that is recognized by law. So if anybody in the state or in the local government is aggrieved or feels like the committee is not dancing to his tune or is not producing what he wants and decide to form another parallel committee, it is not a problem for us because we have complied with the provisions of the law and the guidelines of the party. So you can have 100 parallel factions or parallel body or parallel committee of functions in a state. They are exercising their right of forming association. But when they exercise that right, they have to know that right is determined by law. If it is not founded on the guidelines of the party, is not founded on the constitution of the party, it is an exercise in futility. It is not a problem. It is not as though heavens are falling. If you go to any political party now, where you are going to conduct a world election, whatever it is in the conduct of election or electing leaders, you are going to find that people who were there before, who had control of the what do you call it, of the structure, will want to control it.
Mr. Boala, you know what I'm a bit puzzled about is there are processes towards internal elections in the party, such is similar to general elections. In this kind of election,
Right.
after a starting stage, the World Congress, there is an appeal committee that is set by the party to listen to the grievances of people. And when we wonder that some of the states that have problems in the World Congress are still the ones having problems in the local government. So it does look like the appeal process has fallen flat on its face.
Well, the constitution of our party is clear regarding the procedure for airing your grievances before you even think of approaching the court. Usually, even if you look at this, our guideline, there is an appeal committee for every committee that is established to conduct the World Congresses or the local government congress, or even consequently conducting primaries. Now, that is why, to me, is a waste of time for somebody to create a parallel committee or parallel group or parallel executive, because you already have a well-established procedure for airing your grievances. Assuming in the committee that is formed to conduct the World Congress or the local government congress in your state, you feel aggrieved by it, there is no need to create another parallel committee. You go to the appeal committee and lodge your complaint. Don't forget that even the decision of the appeal committee is subject to the National Working Committee, in this case, the Extraordinary Caretaker Committee. And then their decision becomes final, of course, subject to final ratification by the National Executive Committee. So there is a laid down procedure. But you know, Nigeria, if you look at it, that is why we're even talking about conflicting orders of court. Nigerians are not willing and ready to follow procedure. If you go to the fuel station, somebody is not ready to follow the queue. If you go to the market, somebody is not ready to. So it is natural, it is instinctive in every Nigerian, or most Nigerian. And so you find that in political party. But what we are particularly concerned about, what you have is a control over your emotions and your action. And as a political party, what we have is control over our conduct in relation to what the law that we set for ourselves to guide us provides. In this case, the Constitution and the guidelines. So any committee or any executive that emerge outside of the laid down procedure, you don't even need to have a sleepless night, because it is a committee that is organized for the purpose of having maybe football friendly match. It will not have the force of law. It is just like the mischievous interpretation that people are giving to the order of court in Delta, and that they are saying that the court in Delta has bound the national chairman and barred everybody from the conduct of the election. If you look at the order that was granted by the court in Delta only restrained the state chairman from conducting the congresses. And by our law, it is not the state chairman or the state party that conduct what Congress is. It is
All
the
right.
National Working Committee, in this case, the Extraordinary Caretaker Committee. So that order has nothing, absolutely nothing to do with the conduct of the World Congress that was, the local government Congress, and all of the Congresses conducted in Delta. But people are giving a mischievous interpretation to make it seem as if
All right.
the court has restrained the national chairman from parading himself, or restrained, in fact, the party from conducting Congresses there.
Let me switch gears now and get over to Mr. Jibrin Okutakpa, Senior Advocate of Nigeria, on the planned meeting of the NJC, the Chief Justice of Nigeria's meeting with the heads of some courts. Thank you so much for your patience, Senior Advocate, and let's get started. What do you suppose that the CJN will be telling the heads of these courts over what we now know, the meeting agenda to be the conflicting court orders?
Well, thank you for inviting me, even though I'm far away from Nigeria. Well, I'm not a clairvoyant lawyer, so it will be difficult for me to know what the Honorable the Chief Justice of Nigeria will be telling their lordships, the chief judges that he has invited. But if you ask me, I've written that what we are seeing as what I call professional sacrilege of these orders shouldn't end merely in invitation for meetings. We should proceed further than that, because the use of ex parte orders in the circumstances that we are witnessing, if it is not nip in the bud, very shortly there may be an ex parte order removing the President of the Federal Republic of Nigeria from office. And that will bring us to a more ridiculous situation than we have found ourselves. So it's a welcome development that the Honorable the Chief Justice of Nigeria is inviting the heads of courts. But my admonition and advice is that we should go beyond that. The people who are involved, like I wrote in my write-up, are not unknown gunmen, like unknown gunmen you have here. They are known lawyers and known judges with known ethical rules and rules of professional conduct for the judges and for the lawyers. So we should proceed by laying complaint before the appropriate authorities that has responsibility to determine the culpability or otherwise of the ex parte orders. Mark you, there are code of conduct for judicial officers, and the authority that is responsible for their disciplinary process is the National Judicial Council, of whom the Honorable the Chief Justice of Nigeria is the chairman. The invitation is welcome for the heads of court to put their heads together, but mark you, none of the heads of court was involved in the orders that was issued. The judges that issued the orders are not the chief judges, if my memory serves me right. Then the lawyers that filed the processes before the court, because Rule 1 of the Rules of Professional Conduct enjoins lawyers to do what is in the interest of justice and not to do anything that will bring the justice system to a total dispute and obloquy. So I will think that the invitation to them is okay, but it should go beyond mere invitation. And the leadership of the Nigerian Bar Association, like I heard from your intro, should also be invited. Mark you, Sheung, I think the problems we have in Nigeria is because we are too economical with sanctions. Otherwise, in other climes where sanctions are visited on people who misbehave, lawyers and judges are supposed to be light of the society. But it appears to me that darkness seems to have overshadowed light in terms of the way we act, we behave, because ex parte order shouldn't be given to remove person from office. Ex parte order is always supposed to be issued in the case of extreme circumstances where the subject matter, what we call the res, is in the danger of being destroyed. In most of the ex parte orders we have seen, what are the res that are to be destroyed? The one, for instance, that removed the the PDP national chairman from the office, for instance, what rest was going to be destroyed if it was to be removed? Then the counter order coming from left, right, and center. We look at even order coming from where they lack territorial jurisdiction. And no Nigerian judges should be ignorant of what is called territorial jurisdiction. Then we talk about subject matter jurisdiction. None of the lawyers who file those processes should be unaware of it. You can't file a process against a man who is in Anambra in a state called Kogi, for instance, even though they have boundary.
Mr. Okutekpa, yeah, let me quickly, apologies to cut into that line of thought. But from the conversations that I've had over this matter, it was apparent from the conversations, even with lawyers, saying that these applications emanate from very privileged members of the bar or within the legal practice. And perhaps they say this is just an ethical matter. Worst case scenario, seen as a misdemeanor simply. And I'd like to know, I tell our viewers tonight, if it's an ethical matter, not a criminal offense, what is the maximum punishment under the ethics of the profession to such a person found wanting in this regard?
The profession I belong to is a profession of life, and we are the chief priests, and we are not supposed to give appearance of impropriety, not to talk about indulging in it. Now, when the lawyer decides to file a process that is downright frivolous, that is downright intended to interfere with the course of justice, there is a conduct that is unbecoming of that legal practitioner. And by the provisions of Section 12 of the Legal Practitioner Act, once such a person is brought before the Legal Practitioner Disciplinary Committee of the Board of Benchers, and the Legal Practitioner Disciplinary Committee of the Board of Benchers is of the opinion that the processes filed ought not to be filed, and no lawyer what is sought ought to have filed such process, we refer to such conduct as an infamous conduct. And the penalty for such things is that the lawyers, they have his name struck up the roll. Now, a judge who knowingly issue ex parte order, which he has no jurisdiction to issue, well, yes, it is an appealable decision, but also by the code of conduct for judicial officers, it also constitutes an offense, and it may, subject to what the NJC decides, it may lead to the dismissal of that judge from his judicial office. And once a judge is ordered to be dismissed from his judicial office, he will no longer practice law in Nigeria. He cannot come to the bar to practice. So that is tantamount also to sentencing such a judge to economic death sentence. So he will not be receiving. So it's not a trivial matter as you see. It's a serious matter that has gone to the foundation of justice. And once the stream of justice is polluted as it appears to be, then the entire society will go like one of your persons you just interviewed said that the judiciary is for the common man. When the common man on the street begin to think that justice has been mortgaged, justice has been bought, then the confidence in the judiciary becomes totally eroded. And once the confidence in the judiciary is eroded, the people no longer have interest, a confidence in the judiciary, then we are returning to what the Hobbesian people call the state of nature, where life will become shortish, brutish, and nasty, and there will be no place for industry. So the totality of the failing we have in our country is because there are no consequences for misbehavior. And these misbehaviors are grievous. And I'm happy that the Honorable Chief Justice of Nigeria is taking on it.
Okay, so you don't have a problem with the intervention of the CJN, which some people might interpret as interference, but it does look like the NJC says it wants to intervene in the matter. But let's look at the solution part of it. The issue is how to stop this kind of behaviors in the future. What can be done? Can we go in the line of legislation in this regard, or perhaps put some stringent ethical measures in the ethics of the legal practice? Just a quick one as a solution to wrap up.
there is inherent solutions in our laws under the rules of professional conduct. The lawyer ought not to do what will bring will be against the cause of justice. Also, the rules of professional conduct for judicial officers is there. The problem, I think, which we have been facing for a long time, is absence of sanction. And that's why I'm happy that the Chief Justice of Nigeria has summoned a meeting of the heads of courts. It should go beyond that. Let the people have their days before the National Judicial Council and the lawyers involved before the Legal Practitioner Disciplinary Committee. There should be no sacred cows. And our ability to have sacred cows is what is leading to a deteriorating situation in our country. Otherwise, if there are sanctions, you will see that judges and lawyers will misbehave. You file a process that you know is outrightly frivolous, outrightly stupid, permit me the choice of that word, and you bring it before a judicial officer who ought to be a master of his court and proceed to grant it, both parties should face the music. And that is always been my admonition. We should ensure that our disciplinary process gives quick solution, quick result. Not that today, as we are hearing now, in the next 2 weeks, the thing will go into historical oblivion. No, because in Nigeria, I understand that a lot of things only have a lifespan. Like my learned friend Daniel Buala will say, that controversy in Nigeria has a lifespan of 2 weeks. Once 2 weeks is over, everybody has gone to sleep. So we must not sleep over this. Let us make example. We have allowed the use of ex parte application to wreak havoc on our judicial system, and time for us to put a stop to it is now.
All right. Thank you so much, Mr. Jibrin Okutepa. Before we close the program, let me get the view of Mr. Daniel Buala on this one. Mr. Buala, we've had this kind of conversation, but now the meeting is tomorrow. What are your thoughts about the NJC's meeting with this head of these courts?
You know, the CJN must have invited those CJs not just in his capacity as the Chief Justice of Nigeria, but as chairman of the National Judicial Council. And he has all of the rights. And summoning them for a meeting does not amount to interfering, because he is not bringing them to discuss on the content of the order, but the disciplinary, the conduct of the order. The conduct of the order rests on section 285, 287 and sub 3. That the court of coordinate jurisdiction must not engage in this kind of orders and counter order. A corrupt judge is more dangerous than a unit of bandits on a rampage, because the unit of bandits on a rampage can be curtailed by the community of help, but the judgment of a corrupt judge destroys the very fabric of the society.
Those are very deep thoughts there. But I sincerely thank you. Mr. Daniel Buala, lawyer and a member of the Lincoln's Inn, and also Mr. Jibrin Okutepa, senior advocate of Nigeria, who's been talking to us from the south in the Bahamas. Thank you so much, gentlemen, for your thoughts. And we'll be looking ahead to that meeting tomorrow. But that's how we draw the curtains of the program tonight. Many thanks, everyone, for watching. And that's our dose for you today. Until I see you tomorrow again at 7 p.m., I'm sure Kimale. Bye-bye.